coordinator and will be presenting today. I would like to thank you for taking the time to be part of this webinar. I hope that it will be beneficial to your organization and look forward to the knowledge sharing that will occur today. The webinar session is planned to run from 1 p.m. till 2, and depending on how the question and answer session goes at the end, we may even end a little bit before 2. I'd like to just quickly go over the agenda of the webinar, which has already been emailed to you in the PDF of the presentation, which you can refer to in case of any kind of technical difficulties. Me and my colleague Elizabeth will then go over some housekeeping rules so then we can share information while also keeping it organized. I will begin my presentation by going over the standards of the Istanbul Convention. Then we'll focus on 2 of the areas of the Istanbul Convention, protection and support and prosecution. This will be followed by a presentation of 3 important case laws of the European Court of Human Rights. I will end my presentation by giving you some examples of countries that have successfully implemented articles of the Istanbul Convention and by presenting a practical tool developed by the Council of Europe, in which WAVE took part. My presentation should take about 35 minutes, after which I will take questions and comments from the audience. So let's go through some technical aspects with Elizabeth.
Okay, hi everyone. As an audience member, you are automatically muted, and we'll keep the muting on until the end of the presentation, after which you'll be able to ask questions during the question and answer part of the webinar. I'm not able to see you, even if your webcam is on, and you will not be able to see us, just the slides of the presentation. If you can't see the PowerPoint, then leave the webinar by clicking the X at the top right of your screen, and you can rejoin the webinar by clicking the link in your confirmation email. This webinar is being recorded and will be available for viewing on our YouTube channel afterwards. Just a few guidelines to make the webinar more enjoyable for everyone. First, we'll have you listen to the presentation, and if you have any questions during the presentation, you can type them into the questions pane, and we will answer the questions at the end of the presentation. During the questions and answers part, we'll not be able to unmute everyone at the same time, but we can unmute individual participants one at a time. So if you have a question or comment, raise your electronic hand and Anka will invite you to give us your questions at that time. We hope you enjoy the webinar. Thank you.
Okay, so firstly, I would like to give you a short introduction of myself. My name is Anka Chupa, and I'm a membership and network coordinator at the WAVE office since September 2015. I'm responsible for projects related to the Istanbul Convention, membership applications, organizing the WAVE conference, among other tasks. Okay, so let's dive into the presentation. Firstly, we will go through the standards and core principles of the Istanbul Convention. So the Convention clearly establishes legal principles and standards in the area of preventing and combating violence against women, offering states, policymakers, and professionals the legal tools to answer questions about what are the minimum standards and measures state authorities need to implement in order to effectively respond to violence against women and domestic violence. When talking about the first principle, due diligence, the Convention requires states to diligently prevent, investigate, punish, and provide reparation for acts of violence against women and domestic violence covered by the Convention. Failure to do so triggers states' responsibility for an act that otherwise should be solely attributed for a non-state actor. This is Article 5.2 of the Istanbul Convention. The next standard tackles gender equality. The Convention frames the eradication of violence against women and domestic violence in the context of achieving de jure and de facto equality. To overcome inequality and prevent violence, the Convention requires states to implement gender equality policies and to empower women through prevention mechanisms such as awareness raising, as Article 13 says, and training of professionals, Article 15, for example. The victim-centered approach of the Convention puts the emphasis of the importance of treating victims with respect and sensitivity and putting their rights, needs, and safety at the core of all interventions. This is Article 56 that requires a victim-centered approach throughout investigative and judicial proceedings. The Convention covers women and girls from any background regardless of their age, race, religion, disability, social origin, sexual orientation, gender identity, migrant, or other status, and prohibits discrimination on any grounds when providing protection and support. Article 4.3 of the Istanbul Convention. The Convention recognizes that these that there are groups of women and girls that are often at greater risk of experiencing violence, and states need to ensure that the specific needs are taken into account. To be able to empower and protect the human rights of women, a gender understanding of violence against women and domestic violence should be at the base of all measures. Article 18.3. When it comes to the gender understanding of domestic violence, all provisions of the Convention except articles on female genital mutilation and forced abortion and sterilizations have been drafted in a gender-neutral language, meaning that the Convention applies to all victims of violence, including men and boys. Particular attention must be paid, though, to women victims of violence, as Article 2 emphasizes. For the children as victims and witnesses principle, several provisions of the Convention address both children as direct victims of physical, sexual, or psychological violence and children who witness such violence between parents or other family members. The coordinated and multi-agency approach principle implies that all relevant actors playing a role in preventing and combating violence against women and domestic violence need to coordinate and cooperate among themselves to effectively respond to such a complex, multi-faced problem. This is Article 7.1 of the Istanbul Convention and Article 18.2 of the Istanbul Convention. Good practice examples show that results are enhanced when law enforcement authorities, the judiciary, victim support services, child protection agencies, non-governmental organizations, and other relevant partners join forces to develop a comprehensive and coordinated response. The Istanbul Convention also recognizes in Article 2 the work and valuable input of non-governmental organizations in this field, asking states to effectively cooperate with them. Next up, I will start talking about the 4P structure of the convention, but I will focus on only two of them today, and the first one is protection and support. When preventive measures have failed and the violence has happened, it is important to provide victims and witnesses with protection and support. This means police intervention and protection, as well as ensuring the victims access to support. The Convention requires states parties to respond promptly and appropriately, provide adequate and immediate protection to the victim, as Article 50 of the Istanbul Convention says, ensure risk assessment and risk management to keep the victim safe, Article 51 of the Istanbul Convention, introduce emergency barring orders, protection orders, and restriction orders, this is Article 52, 53 of the Istanbul Convention, set up shelters in sufficient numbers and in wide geographical distribution, Article 23 of the Istanbul Convention, ensure that general support services can support or refer victims of all forms of violence against women, Article 20 of the Istanbul Convention, introduce a free-of-charge telephone helpline, Article 24, set up specialist women's support services for all women victims of violence and their children, Article 22, set up rape crisis centers or sexual assaults referral centers, Article 25, ensure access to clear information in several languages, Article 19. All these measures taken should be based on a gender understanding of violence against women and domestic violence, take into account the specific dynamics and consequences of violence against women and domestic violence, focus on the rights and safety of the victim, avoid secondary victimizations, and aim towards the victim's empowerment. This is Article 18 of the Istanbul Convention. The Convention also requires state parties to criminalize the following forms of violence against women. So it's domestic violence, physical, sexual, and psychological, stalking, sexual violence including rape, sexual harassment, here it's to criminalize it or to either sanction it, forced marriage, female genital mutilation, forced abortion, and forced sterilization. Respecting victims' rights and having a gendered understanding when dealing with violence against women and domestic violence are core principles to be taken into consideration at all stages of the criminal proceedings. All the offenses shall apply irrespective of the relationship between the victim and the perpetrator. This is Article 43 of the Istanbul Convention, and no culture, tradition, or so-called honor can be regarded as a justification for any of the forms of violence covered by the Convention. This is Article 42. Judicial proceedings related to all forms of violence are to be carried without undue delay and in an effective manner in order to secure vital evidence, enhance conviction rates, and put an end to impunity among perpetrators. Article 49. Law enforcement agencies are obliged to promptly and appropriately react to an act of violence, including the employment of preventive operational measures and the prompt collection of evidence. This is Article 50. State parties are required to provide for the right to legal assistance and free legal aid for victims under the conditions of their internal law, Article 57. Additional measures of protection, such as protecting the privacy and the image of the victim, providing separate waiting rooms, and allowing victims to testify without the presence of the alleged perpetrators, are highlighted in Article 56. The Convention also talks about ex officio, which are proceedings started by the prosecutors, and ex parte, which are proceedings started by the victim, and requires state parties to ensure that investigations into and prosecution of the different forms of violence covered by the Convention is not wholly dependent upon the victim's report, and that proceedings may continue even if the victim withdraws their complaint. Evidence related to the victim's past sexual history and behavior should not be considered as an excuse for acts of violence against women and domestic violence, as it can lead to allowing the perpetrator to be exonerated or to diminish his liability. However, due to the fact that the consideration of evidence lies within the discretion of the judge, Article 54 also entails that parties will have to take the appropriate legislation to ensure these types of evidence shall be permitted or considered only when it is relevant and necessary. Next up, we're gonna talk a bit about the European Court of Human Rights case law, as the European Court of Human Rights has played an important role in shaping and strengthening the international framework of violence against women. Many of the obligations identified in the European Court of Human Rights are now codified as obligations to state parties in the Istanbul Convention, these two instruments being actually interconnected. I will present to you three of the case laws where states have failed to diligently prevent, investigate, and punish acts of violence against women and domestic violence. Due to the focus of the European Convention on Human Rights, on civil and political rights, the state obligations in relation to violence against women are drawn from rights such as the right to life, which is Article 2 of the European Convention of Human Rights, the prohibition of torture, Article 3, the right to respect for private and family life, Article 8, or the prohibition of discrimination, Article 14, and are thus concentrated on the criminal justice system's adequacy when dealing with cases on violence against women. The first case that I want to present to you is Opus versus Turkey from 2009, where the European Court of Human Rights held that domestic violence is a form of gender-based violence and constitutes a form of discrimination, as Turkey failed to set up and implement a system for punishing domestic violence and protecting victims. The court highlighted the due diligence principle of states to take the appropriate actions to address violence against women. The facts of the case are the following. The applicant alleged that Turkish authorities had failed to protect the right of life of her mother, who was killed by the applicant's husband. With only one exception, no prosecution was brought against the husband on the grounds that both women had withdrawn their complaints, despite their explanation that the husband had harassed them into doing so, threatening to kill them. The applicant further complained about the lack of protection of women against domestic violence under Turkish domestic law. So what did the court say? The court found that there was an infringement of Article 2, which is right to life, concerning the murder of the applicant's mother. Article 3, prohibition of inhuman or degrading treatment, concerning states' failure to protect the applicant, but also Article 14, which is prohibition of discrimination, in conjunction with Articles 2 and 3. It's for the first time in a domestic violence case where the court held that gender-based violence constitutes a form of discrimination, because it mainly affects women, and women were not protected by the law on an equal footing with men. As the national authorities had dropped the proceedings in order to avoid interfering in what they perceived to be a family matter, without considering the motives behind the withdrawal of the applicant's complaint, the court also observed that in a domestic violence case, perpetrators' rights could not supersede victims' rights to life and physical and mental integrity. Similarly, the Istanbul Convention in Article 55 states that investigations into or prosecution of offenses related to violence against women should not be wholly dependent upon a report or complaint filed by the victim. The next one is Kontrova versus Slovakia, which is an European Court of Human Rights case example where the law enforcement findings were supported only by the victim's declaration. The facts of the case are that the applicant filed a complaint against her husband for assaulting her and beating her with an electric cable. Accompanied by her husband, she later tried to withdraw her criminal complaint. She consequently modified the complaint so that her husband's alleged actions were treated as a minor offense, which called for no further action. 2 months later, her husband shot dead their daughter and son. Before the European Court of Human Rights, the applicant alleged that the police, aware of her husband's abusive and threatening behavior, had failed to take appropriate action to protect her children's lives. The court held that there had been a violation of Article 2, which is right to life, of the European Court of Human Rights concerning authorities' failure to protect the applicant's children's lives. It also observed that the situation in the applicant's family was known to the local police, given among other things the first criminal complaint and the emergency phone calls in between. In response to the applicant's situation and under the applicable law, the police had been obliged to register the applicant's criminal complaint, launch a criminal investigation and criminal proceedings against the applicant's husband immediately, keep a proper record of the emergency calls and advise the next shift of the situation, and take action concerning the allegation that the applicant's husband had a shotgun and had threatened to use it. In conclusion, the police had failed in its obligations, and the direct consequence of these failures had been the death of the applicant's children. A more recent case from 2017 is Tulpas versus Italy, which concerns domestic violence and illustrates the authorities' failure in their obligations to protect against acts of domestic violence, as well as the inaction of the authorities, which have underestimated the violence in question and thus essentially endorsed it. Mrs. Tulpas, which is a mother of two, has complained in 2012 that her husband, who was an alcoholic, had beaten her and her daughter. At this stage, she did not lodge a formal complaint. 2 months later, she was once again attacked by her husband with a knife, forcing her to follow him in order to have sexual relations with his friends. This has happened in a public sphere, so a police patrol who was nearby intervened by fining her husband for carrying a prohibited weapon and sent Miss Tulpas home. As a result of the attack, she suffered a head injury noted by the doctors and was taken to a welfare association for female victims of violence, period during which her husband continued to exert psychological pressure on her, in particular by phone. Ms. Tulpas lodged a complaint for bodily harm, ill treatment, and threats of violence, urging the authorities to take prompt actions to protect her and her children. But her husband was only fined €2,000 in October 2015. In 2013, her husband, in a state of intoxication, entered the family apartment and attacked Ms. Tulpas. He stabbed his son, who tried to separate his parents and who died of his injuries. The court found a violation of Article 2 on account of the murder of Mrs. Tulpas' son and her own attempted murder, of Article 3 on account of the failure of the authorities in their obligation to protect Mrs. Tulpas against acts of domestic violence, and Article 14 in conjunction with Article 2 and 3. By failing to take prompt action on the complaint lodged by Mrs. Tulpas, the national authorities basically have deprived that complaint of any effect, creating a situation of impunity conducive to the recurrence of the acts of violence, which had then led to the attempted murder of Mrs. Tulpas and the death of her son. The authorities had therefore failed in their obligation to protect the lives of the persons concerned. We will now move forward to some good practice examples that are in line with the articles of the Istanbul Convention. The first example comes from the first Grevio baseline evaluation report from Austria. The system of emergency barring orders and protection orders for victims of domestic violence is well established and widely considered a success. Further changes to Austrian legislation, in particular in the areas of criminal law, have led to a comprehensive list of criminal offenses and extensive legal and psychosocial court assistance to victims of violent crime and sexual offense. This is in line with Article 55.2 of the Istanbul Convention. Also, reporting obligations have been introduced for a broad range of medical professionals to help victims disclose abuse and be supported. This is in compliance with Article 28 of the Istanbul Convention. Another good example comes from Spain and Sweden, countries that have both indicated to Grevio that they have implemented Article 10 of the Istanbul Convention. Both countries set up their structures independently before the Istanbul Convention entered into force. In Sweden, for example, the coordinating function is performed primarily by the Division of Gender Equality within the Ministry of Health and Social Affairs. In the UK, when it comes to forced marriage, started with June 2014, it became a criminal offence, along with using deception with the intention of causing another person to leave the UK for the purpose of forcing that person to enter into marriage. The victim has the ability to take action against perpetrators through civil and criminal courts, this being in line with Article 37 of the Istanbul Convention. To conclude, I would like to draw your attention to a training tour for the human rights education for legal professionals, which is HELP, which is a platform of the Council of Europe. At the Council of Europe's initiative, HELP Division, WAVE was invited to work together with 3 other experts to develop an online course on violence against women and domestic violence. The course is designed to train legal professionals on the issue of violence against women and domestic violence, and it is based on the standards elaborated by the Istanbul Convention. It has the purpose firstly to inform legal professionals about the problem, raise awareness about the standards of the Istanbul Convention, and train them when working with victims of violence to adopt a victim-centered approach. The course contains 7 modules from understanding violence against women and domestic violence to international and European legal framework to overcoming barriers to justice, criminal justice response, civil justice response, and alternative dispute resolution. This course will be available online in the upcoming weeks. I think it's beginning of December, and can be accessed by anyone who has a HELP account, being free of charge. This course will also be translated and adapted to most of the national legislations of the Council of Europe countries. In this PDF presentation that you have received, you will find the link to the HELP platform where you can actually create your own account. On this note, I would like to end my presentation here, to thank you for your attention and to open the space for questions. Just to let you know, the video of this webinar will be made available in a few weeks. I may have to edit it a little bit before sending it out. Also, there will be a worksheet which summarizes all the information that you received today. I will send it out by the end of next week at the latest. Okay, so let's start by answering some questions. If you have any questions or comments, please raise your electronic hand. You can still write it in the questions pane if you don't feel like speaking. You could also share practices from your experience. I will give you a minute to think about your questions. Okay, so I've seen a hand from Mahamuna. I will now unmute you. Unmute you, please. Do you have cases involving violence against girls?
Yes, thank you. Can you hear me?
Yes, please go ahead.
Okay. So with the Istanbul Convention, it's violence against women and children. So I'm wondering, I mean, you've given one case in which the son was killed in the process, and so I'm wondering if you have specific cases where the perpetrator was attacking children, you know, where it was issues of, for example, child abuse or.
Yes, I can remember of a case. It's actually an older case from Bulgaria. It's called Beva. I hope I'm pronouncing it right. Bevarovka versus Bulgaria. And in that case, it was a case when the perpetrator actually attacked the child. But what I can do for you is, when I'm sending all this information, on the Council of Europe website, there are 2 information sheets on all the violence against women cases concerning also children, with cases from the European Court of Human Rights. And if it would be helpful, I can send it to everybody just for their own knowledge.
Thank you.
Thank you as well. Okay. Another question that I received as regards to the online training, will it be possible to be followed by our lawyers? What are the fees? Yes. So the online training that we created is free of charge. That means you just need to have a help account. The link was in the slides. You create a help account and you can access the online training, and everybody can follow it. And yes, it can be followed also by lawyers because it's designed mainly for legal professionals. The purpose is basically to then send it firstly to train legal professionals, lawyers, prosecutors, and judges, and then also promote it in law universities. Yes, so we got, yes, the case is Bevavka versus Bulgaria, sorry, application number 71127 from 2001. Thank you, Diliana. Other questions? Oh yeah, there is one. Anastasia, I've seen you. We will unmute you now so you can ask your question. Hello, can you hear us? Anastasia? Anastasia Kelam. Okay. In the meantime, we have received a question in the PAN. I would like to ask, when will the help training for the Istanbul Convention be available? So we now have a final draft that needs to be proofread, and probably in 1-2 weeks it's going to be online. Do we have other questions? Okay, Anastasia, yes, please write your question in the PAN. We will see it. You mentioned that the training is also available for students. Is it possible to be followed by a rather large group of students at a time, or is it rather individual work? Okay, so the training is individual work. Basically, everyone who has an help account can access the training and has to go through training and pass certain tests, and then they will get a certification that they have passed the test. So it's individual work. It can be, of course, if the training is translated into your international language, it could be the case that they can present it at in universities, but this would be up to the country. Okay, so we have a comment from Anastasia from Greece. She says, I'd like to say that the steps that every woman needs to take are slow, and I'm not sure. Okay, she's still typing. Okay. In the meantime, do we have other questions? Okay, so Anastasia is saying that the steps every woman need to take are very slow, and she's not sure if the convention really helps. Well, I actually have a different opinion, because for me personally, the Istanbul Convention is a great tool in terms of the standards that it offers. It really offers rules when it comes to the common sense of how to treat victims. Um, and it's true, it's also about implementing it into the national countries, and there's a different story. But I think, like, if everybody gets appropriate training for the on this matter, then it's also a way in changing attitudes towards victims of violence. Okay, so we have another question from Eugenia related to Italy, but we are waiting for you to type the question. Eugenia, we have unmuted you. Maybe you want to speak? Here, maybe.
Okay.
Okay,
Yes.
hello.
Okay. Can you hear me?
Yes, we can hear you.
Great. Okay. So my question is the following.
Yes.
In Italy, about a year ago, the parliament adopted adopted legislation that introduces ex officio prosecution in the cases where victims where victims go to the hospital, to the emergency rooms in hospitals, and the hospitals identifies them as victims of violence.
Okay.
Yes, so there was a big debate, and many the NGOs were advocating against this because it says it goes against the, let's say, right to self-determination of the survivors to decide whether to report or not, because they are the ones who know better how dangerous their situation is. If they can face repercussions, if the prosecution starts, then the husband or the partner can become more violent and so on. So I was a bit surprised about this debate, because I have myself worked a lot, including with WAVE, in other countries, in Moldova, for example, and we pushed a lot for ex officio prosecution. So can you, maybe
Comment on it.
give me your view on this? Yes.
Well, from my point of view, this is also what happened in Austria, because and Grevio said it's actually a good practice, because what Austria did, have extended their reporting obligations for a broad range of medical professionals, because I think this is actually what you're saying, that medical professionals, when victims of violence come to them, they have to disclose the abuse. And
yes,
it's tricky, actually. I don't know. From one point of view, if the abuse is I don't know, how should I put it. If it's a very serious crime, then I think it should be reported, because sometimes victims of violence, they don't have the courage, don't know the pressure that they are upon. They can be, but if they do, because if they don't speak, like, the abuse can get worse. But also, it's true, some of the comments that the NGOs made regarding the law is that it are true, in the sense that it can happen that the situation of the victim gets worse. But if it gets worse, it means it also that the necessary steps to protect the victims have not been taken into account.
Okay.
Because from my point of view, in the moment that she discloses the crime, or the medical professionals disclose the crime, in that moment, certain steps to protect the victims should be taken into consideration, and also risk assessment should be made to see if actually this is the situation is of high risk or not, and
Yeah,
if the
exactly.
woman should be put in the women's shelters, or all these factors. So I think it's a case-by-case basis. I don't see it as a bad thing. Bad thing. Also, apparently, Grevio didn't see it as a bad thing in Austria's case. It could be a step forward, but also you have to take into consideration all risks.
Yes. Thank you. It was very, very comprehensive.
Thank you very much as well. Okay, do we have other questions? I don't see any raised hands or questions in the pane. All right. Okay, so it looks like I have answered all of your questions. I would just like to thank you for your attending my webinar, and I hope to see you all participate at our next upcoming webinar, which is on November 22nd, which will be on the new Wave Communication FemPower and Wave blog. Thank you very much again, and I wish you all a good day and all the best from the Wave office.